We have one more term to complete the definition of public records. A public record is a record kept by a public office. This means all records actually kept by the office and not just the records it is required to keep. If a record is typically and actually retained by the office in the ordinary course of its business to carry out its duties and functions, it is probably kept by the office for the purposes of the Public Records Act. If a document has not yet been received or created, then it is likely not kept by the office and is not a public record subject to the Act. A situation where it may make sense for a public office to go above and beyond its obligations under the law is where a requester has asked for a record that does not yet exist or that has not yet come into the possession of a public office, but the public office knows it will have in the near future. Rather than denying the request and forcing the requester to continually make the same request until the public office actually has the requested record, the public office could agree to treat the request as a standing one and provide the requested record once it is received. In that situation, the public office has saved itself time by not having to continuously respond to the same request. And the requester will likewise benefit from not having to make the same request over and over again. The kept by requirement also means that if an item was once kept by the office and properly disposed of or returned, that item is not a public record. An example of this comes from the 2003 Ohio Supreme Court case, State ex rel Cincinnati Enquirer v. Cincinnati Board of Education. In that case, the Cincinnati School District conducted a search for a new superintendent. The district contracted with a nonprofit to assist in the search process. Ultimately, the field of applicants was narrowed down to 5 finalists who were asked to bring application materials with them to interview with the school board. At the interviews, the board president told the finalists that any materials they decided to leave with the board or its contractor would be provided in response to public records requests. Only one finalist opted to leave his materials with the board at the end of the interview. The finalist who was ultimately hired also provided the materials he brought to the interview, and they were made a part of his official file. The other finalists took their materials with them, and neither the board nor its contractor had any copies. When those materials were requested, the board produced what the superintendent and the one finalist who opted to leave his materials provided, but did not produce what the other finalist brought to the interviews because it did not have copies. In that case, the Ohio Supreme Court concluded that the application materials the finalists did not leave with the board were not public records because neither the board nor its contractor kept them. Importantly, the school board and its contractor were not required by law or policy to keep them. Finally, the kept by part of the definition of a public record means that a public office has no obligation to produce records properly disposed of, even if there are distribution or personally retained copies of the item elsewhere in the office. But if the office keeps the record copy of an item past the date when it could be disposed of, and a public records request is made while the item is still being kept, the item is still a public record subject to the Public Records Act. The message to public offices is pretty clear. Keep up with your disposal schedules, and you reduce the volume of records that can be requested. The Public Records Act does not apply to non-records, but that does not mean that non-record information is always confidential. Non-record information can be redacted or removed, but does not always have to be. We'll discuss redaction more later, But one example here could be an employee home address contained in a civil service application form. The application form is a record documenting the activity of the office in evaluating the qualifications of an applicant. But the home address is a non-record that may be redacted or blacked out before releasing the rest of the form. On the other hand, the fact that an item is a non-record does not prohibit the office from producing it in response to a citizen request. For example, take an email that contains record information that concludes with one public employee asking another public employee if she wants to go to the new restaurant down the street for lunch. That personal lunch invitation does not document the activities of the office and is a non-record. But the public office could simply release the entire email without redacting the non-record information if it so chooses. Before releasing non-record information, however, a public office should check to make sure it is not subject to any limitations on its release. For example, is the non-record information protected by the Personal Information Systems Act? The Personal Information System Act, or PISA, generally governs the use and maintenance of personal information systems by state and local agencies and applies to items which the Public Records Act does not apply. PISA is one example of law that could prohibit the release of non-record information. Let's turn our attention to notes. A note might be a telephone message slip or a post-it with typing instructions, or scribbled notes for later timesheet entry. It might be personal correspondence. But not everything a public employee writes words on is a record of the office. Each particular note might be a record, or it might not be. You need to apply the definition of public record to each note that is requested. Courts usually look at 3 factors to determine whether notes are records. Notes are not records if 1, they are personal papers, 2, used for the employee's personal convenience to recall events, and 3, others did not use or access them. This test comes from State ex rel. Cranford v. Cleveland, a 2004 Ohio Supreme Court case. Cranford involved the issue of whether notes taken by a City of Cleveland employee during another public employee's pre-disciplinary conference were subject to disclosure. The court found that they were not records because they were used for the employee's personal convenience to recall events and were not official records. In addition, there was no evidence that any city official used or accessed the notes. Personal notes and schedules also may not be records if they do not document the activities of the office. In a case before the 10th District Court of Appeals, the court concluded that then Governor Voinovich's personal calendars and appointment books that were maintained for his convenience and that did not document official functions or activities of the governor's office were not public records. One final example involving notes comes from Doe v. Tetrolt, a 2012 decision from the 12th District Court of Appeals, where the court concluded that scraps of paper an employee used to record time worked before entering that time into an online hour management system were not records. There, the public employer did not even know the scraps existed. The 12th District, citing Cranford, explained that the scraps were used for the employee's convenience, were not kept as official records, and no other officials had access to them. Each case will have different facts, so a public office will want to consult with its legal counsel if there are questions about particular circumstances. There is an important difference between something that was never a record to start with, like personal notes, and something that is a transient record subject to quick disposal, like an official note. Notes documenting office matters are more likely records, but may be transient records used only to remember something until it is transferred to a file, database, written report, etc., or until it is no longer of administrative value. For these types of records, public offices should adopt a records retention schedule to establish agency policy for how they are treated. Many retention schedules provide that transient records may be immediately destroyed once the particular record is no longer of administrative value. Many types of records may qualify as transient, so it is important that public offices have retention schedules that address their disposal. There is nothing in the Public Records Act itself that allows a public office to destroy transient records. What about drafts? Are drafts public records? Generally, the issue is whether the document is something kept for just personal use or whether it was circulated and shared with others. Records like circulated drafts must be provided in response to a public records request. Unlike notes, drafts are considered to document the policies, operations, or other activities of the office to which they relate, even though they are not in final form. There is nothing in the Public Records Act that limits a public office's obligation to provide only final versions of requested records. In State Ex Rel. Calvary v. Upper Arlington, the Ohio Supreme Court addressed a city's failure to provide a written draft of a tentative verbal agreement the city reached with a union that was provided to City Council. The city manager did not release the draft before the requester filed suit because of ongoing negotiations with the union on the terms of the agreement. The city did eventually release the draft after suit was filed. The court concluded that the requester was entitled to the draft agreement. The court explained that even if a record is not in final form, it may still constitute a record for purposes of the Public Records Act if it documents the organization, policies, functions, decisions, or other activities of the office. There, the court reasoned that the draft agreement documented the city's activities by documenting the city's version of its agreement with the union, and it was submitted to City Council for approval. As a practical matter, when a public office produces a draft, it may want to make the requester aware of the status of any drafts. An office can explain in a cover letter if a produced document is a draft, or could stamp or label the record draft. A public office may also want to manage drafts through its records retention schedules. Unless there is a reason to keep earlier drafts of a policy, memo, contract, or other office documents, a public office might include both notes and drafts in its transient record schedule and consider defining the retention period as until no longer of administrative value, after which those records could be disposed of immediately. This is an individual choice to be made by each public office.